One of the most important questions clients have is, how much is the case worth? I always tell my clients what the case is worth within a range once we have sufficient information within which to assess the case. It's not professional, in my view, for lawyers to give ballpark estimates of what a case is worth. We'll be happy to sit down with you and give you a written opinion about what your case is worth once we have the medical reports, we have the reports of the experts and other specialists involved in your case. That is what professionalism is all about. However, I can give you some basic information about how damages are determined, so you'll have an indication of what the pain and suffering aspect is worth. Pain and suffering damages in Canada, unlike the United States, is limited. And I'm going to talk to you a few moments about the law, and hopefully you will shed some light about how damages are determined. In 1978, the Supreme Court of Canada set guidelines for the quantification or determination of damages. They imposed a cap or rough upper limit as to the amount you can obtain for the most serious or catastrophic injuries. This cap was set at $100,000. In subsequent cases, the Supreme Court said you add on inflation. In 2009, the maximum awarded for catastrophic injuries such as quadriplegia, paraplegia, severe brain injury is approximately $327,000. The amount increases by the rate of inflation. Why are damages lower in Canada than the United States? The Supreme Court of Canada said for policy reasons, no amount of money could ever compensate somebody whose life has been ruined. $100,000 was determined to be an appropriate compromise. $100,000, as I mentioned earlier, is now approximately $327,000 for the catastrophic cases in 2009. Pain and suffering damages are not meant to compensate you for a life of pain and suffering. They cannot, and the court recognized that. No amount of money can compensate somebody who's become brain injured or has to spend the rest of his or her life in a wheelchair. Pain and suffering damages, Supreme Court of Canada said, is solace for misfortune. It's provide you with money to make you feel better, or as best as money can do it. So they set an arbitrary amount and imposed a cap or ceiling. That cap or ceiling enables certainty, enables lawyers such as myself to give you an indication of what your case is worth. If you have a broken leg with some hardware, or plates and hardware put in, with some scarring, with some arthritis, we can tell you what the cases have determined that case is worth. Every case brings with it an assessment of pain and suffering, but that's only one aspect of a claim for damages. I'm now going to talk to you about the various aspects of a damage claim. I've already mentioned about pain and suffering and how it's limited to $327,000 plus the accumulated inflation from this point forward for the most serious cases. But that's only one part of the claim. Injured accident victims, or victims of medical or hospital malpractice, or any person injured as a result of the wrongful act of another, is entitled to damages for pain and suffering, damages to compensate for loss of income and future loss of income. That means if the person has been affected in the ability to work in the future, or has been compromised in his or her position in the workforce. We all know that if somebody sustains a serious injury, they're going to be less advantageous or less marketable than somebody else who hasn't been injured, particularly if they're doing physical work. And as we all know, somebody who's doing physical work who's had serious injuries may not be able to do that to the normal retirement age, or may not be able to compete with other people who have not had injuries or have not been so damaged. There's also claims for future care costs. In a serious case, for example, a brain injury case, or a case involving quadriplegia or paraplegia, the care costs are enormous and will result in the millions of dollars. These are the costs for nurses, attendants, medical devices, renovations to a house or accessible housing, accessible vans and other vehicles, and these costs amount in the millions of dollars. That's another aspect of damages. Every claim as well includes a claim for interest. Prejudgment interest is an amount that the courts award on the pain and suffering and on the pretrial losses of income and other expenses that have incurred prior to trial. Every family member of an injured person has a right to claim compensation. Who are the family members who can sue? The spouse, the children, the mother and father, the brothers and sisters, the grandparents, and grandchildren, depending on each particular case. These are called Family Law Act claims, and each family member, depending on the case, can put forth a claim. So this, in a nutshell, will give you an indication of what to expect in a typical personal injury claim.